Hi, and welcome to this webinar on disputes in special education, why attorneys choose mediation over litigation. I'm Dr. Constance Little, and I'm here today with fellow ODR mediator, Dr. Vicki McGinley, to share with you some highlights about why special education attorneys are choosing mediation over filing for due process hearings. These assertions are based upon our research and observations as professional mediators, as well as attorneys and ODR mediators' shared accounts, for which we are most appreciative. I'm a clinical professor of special education at Drexel University, having created the collaborative special education law and post-baccalaureate certificate, and I'm ODR's evaluative mediator. I use my education and my many years of experience as a special education and regular education teacher, parent attorney, school district attorney, hearing officer, appellate panel hearing officer, IEP facilitator, and mediator to assess each party's situation and facilitate evaluative mediations. Every dispute is unique and every mediation personalized. Vicki.
I'm very thankful to be here today with Dr. Little. I'm also today here serving as a mediator for the Office for Dispute Resolution. I am a professor of special education at Westchester University as well, having taught for many years the graduate level course, Legal Issues in Special Education. I am also an IEP facilitator for the Office for Dispute Resolution and have served as a hearing officer there in the past and presently still serve in that capacity in the state of Delaware. My additional professional experiences are as a special and general education teacher in the K-12 classrooms and as an administrator of therapeutic support services. I very much value mediation and look forward to presenting today's work. In this webinar, we're going to offer a brief overview of early dispute resolution options, emphasizing facilitative and evaluative mediation, and share some reasons why attorneys would encourage their clients to participate in mediation. We'll also review the procedures followed by most mediators, and then some best practices to consider for a successful mediation session. Okay.
This is the Center for Appropriate Dispute Resolution in Special Education, or CADRE's, continuum of dispute resolution processes and practices. In this interactive chart, a link to which is offered on this slide and at the end of this PowerPoint and the resources slide, the process level is across the top, where users will find broad categories that mirror 5 stages of conflict with degrees of intervention for each stage. The continuum suggests at the 3rd stage, the level of conflict, that disagreements may be resolved through the assistance of a neutral, such as in mediation. The chart does not distinguish the various types of mediation, 2 of which we will focus on during this session.
Facilitative mediation is a process during which the parties voluntarily meet with a trained mediator who's neutral. All mediators have their own style, but generally the elements of mediation include an opening statement by both parties, followed by discussion and brainstorming of solutions, caucusing when needed, and hopefully the formation of a mediation agreement. The facilitative mediator uses traditional mediation techniques such as questioning, brainstorming, and caucusing to assist the parties in developing a settlement and hopefully avoiding a due process hearing. If the facilitative mediator has thoughts and ideas on possible solutions, rather than make those suggestions, the facilitative mediator may lead the parties to those ideas through very focused questioning. The mediator guides the parties to common ground without interjecting feedback.
An evaluative mediation is basically a facilitative mediation with a reality check. In an evaluative mediation, the evaluative mediator, who is highly trained and experienced in special education law and process, as well as a trained mediator, uses traditional mediation techniques, the questioning, brainstorming, etc., and listens to and assesses the parties' positions and interests, and shares intermittent, non-binding assessments. It's often a series of rapid-fire conversations with balance, give and take, including lots of brainstorming, all dissecting and working each item of the dispute matter to reach a party-drafted agreement. If roadblocks are encountered during the mediation session, or an agreement on certain items cannot be reached, the mediator may offer ideas and evaluative feedback for the parties' consideration. Practically speaking, the evaluative mediator listens to each party's positions and interests and helps them see the value of their proposals, thus helping them analyze their positions and uncover possible weaknesses. We might also brainstorm about potential outcomes of the issues and talk about what a hearing officer might be likely to decide. Although no one can predict what a judge will decide, looking at all the angles helps parties to better create a party-drafted agreement. Evaluative mediation is not a hearing officer settlement conference. It's not the offering of a binding assessment, legal opinion, nor formal decision, and it's not a prejudgment of a case. Working with attorneys on a number of special education cases, one often hears beliefs held that are just not accurate. For example, the hearing officer does not know whether the parties agreed or disagreed to try mediation, or if they even attempted mediation and did not reach an agreement. The hearing officer only knows if the parties participated in mediation if an agreement is reached, and then the agreement is part of the record. Even though mediation does not always result in a settlement agreement, the dispute may be bifurcated and many issues formally settled in a mediation agreement, even if other issues must move forward to a hearing. Even though mediation agreements are legally binding, the signed agreements are enforceable in any state court of competent jurisdiction, but legal precedent is not set in mediation. And finally, mediation agreements may be very creative, much more so than hearing officer decisions, because hearing officers must act in accordance with legal precedents and other guidance.
So in this slide, I'm going to address why attorneys might choose mediation over litigation with specific attention to case benefits. First, mediation may result in written agreements where parties have an increased commitment and ownership to the agreement. Teams tend to be more satisfied and follow through with the terms of a mediated agreement because they're developed together. Mediation sessions are fluid and they're shaped by the parties. Parties are free to fashion the remedy, as Dr. Little just said, not necessarily available within a due process hearing order. Next, through discussion in mediation, the issues may become clearer and include everyone's perspective. A quote from research which I really appreciate and want to share with you here is the following. Mediation allows the parties to revise and adjust the scope of their conflict. In a trial, initial pleadings and rules of procedure limit the issues which a party can raise. In mediation, as circumstances change, so can the topics up for discussion. This increased flexibility makes it easier for negotiators to act as problem solvers rather than adversaries. Number 3, mediations generally last 1 or 2 sessions of informal conversations focused on the needs of the child. So in addition, rather than having to wait for a hearing officer's decision, the parties agree upon everyone's obligations in delivering the child's education and the timeline for that implementation. This is completed at the conclusion of the mediation with a written mediation agreement. And finally, because the mediation team develops the implementation schedule, there is less disruption to the child's educational programming. In the next slide, I'm going to address, again, why attorneys might choose mediation over litigation, but now specifically related to relationship benefits. Mediations are conversations among the mediation participants with a collaborative intent. Thus, it's less intimidating for everyone in the room. It fosters communication and cooperations and focuses on creating a positive plan. There's opportunity to work as a team with a neutral present, and sometimes just having that neutral present there results in positive outcome. The preparation between the attorney and the client may work to enhance the attorney-client relationships. It's a different kind of preparation. So here the attorney is preparing the clients to tell their story and therefore removing the litigation aspects. Attorneys get to know their client's story better. And finally, mediations are collaborative and positive versus litigation, which is adversarial and negative. In this slide, I'm going to talk about the facilitative mediation process. After the mediation is filed, an email introduction beyond what the Office for Dispute Resolution has sent out will follow from the mediator. And in that email, the facilitative mediator will address setting a time to speak with attorneys prior to the mediation, and note that it is their and their client's decision whether the client is present on that call. During the call, the role of the mediator will be explained, issues to be addressed will be discussed, and any process questions you or your client may have will be answered at the time. We noted, though, that the Office for Dispute Resolution is encouraging attorneys to resolve attorney fees outside of the mediation session so that the mediation may focus on substantive issues of the student's program. If this cannot be done, they may be included as an issue to be mediated, of course. Once the mediation has started, all business items will be addressed, such as the forms completed, time restriction, if any, review of mediation rules, confidentiality of the mediation, as well as the conditions of the mediation. For example, that mediation is child and solution focused, confidential, and voluntary. When I mediate, the process for mediation will be explained with specific direction related to caucusing and opening statement. Caucus is explained why I might call one, and parties may call one as well. Additionally, the confidentiality nature of the caucus is addressed. For the opening statement, I direct parties in the following way. I explain that both parties will have a chance for an opening, and while they are providing that we're all listening. The family I ask to go first, and I will ask them to do the following. First, tell me about your child. Tell me what brought you to mediation, and tell me how specifically you would like the matter resolved. Clients may choose to have the opening statement come from their attorneys, but I encourage all parties to speak during the mediation. The district then will have a chance to respond with an opening if they choose, but a lot of times the districts are ready to go right into discussion and solutions. Again, this is ongoing throughout the mediation with discussion, solutions, caucus, and at the end, hopefully a mediation agreement is there to be written. It's written directly at the end of this, drafted with all involved and signed by parties.
Following mediation date confirmation in an evaluative mediation, I want you to watch for the initial email and or phone call from an evaluative mediator to set up a pre-mediation meeting with the mediator where everything shared is held in confidence. This is a pre-mediation meeting always takes place when you have an evaluative mediator and always takes place when there's an attorney involved. Evaluative mediation conferences may be a little longer than a facilitative mediation. And in the pre-mediator conference, the evaluative mediator may ask the family and the school district for their more detailed individual perspectives and seek information about the history of the dispute, what the family would like for the child, and what the school district could do for them, each party's interests and positions, and perhaps conduct a brief brainstorming session of possible solutions. At the mediation, typically the family will go first and provide an opening statement telling exactly what is the dispute and what does the family propose as a solution. What does the family want the school district to do to resolve this disagreement? And when attorneys are involved, the attorneys will decide with their client who would make the opening statement and who would speak. And during evaluative mediations, I hold frequent solution-focused caucuses, probably more focused and more frequently than in the facilitative mediations, because as in facilitative mediations, the parties will write their own agreement. However, I typically ask detailed questions to help clarify everyone's understanding and to assure the parties consider the who, what, where, and when of each item. So there's a preferred demeanor at mediations and some things you should remind your clients that this is a voluntary process. Be willing to think as a team member, to be collaborative. This is not a litigation moment. This is a collaborative time when we're meeting together to come to some solutions. Everyone has different expertise in these meetings and different viewpoints, so you need to listen open-mindedly. We need to be patient and demonstrate respect and stay in the moment. Stay with current issues only. There's a lot of history in many of these disputes, so we need to stay on target, and the mediator will help us do that. Be creative. Look for unique solutions. Be open to all suggestions. Don't shoot anything down when it first comes up. Just put it out there and we'll think about how it might work. So be as creative as possible. And practice brainstorming without judgment. This is the most successful approach. When you're contacted by the mediator for your pre-mediation meeting, attorneys should consider including their clients in that call so they may meet the mediator and tell their story or to ask any questions that they may have about the mediation process. Clients should gather and know their resources, review all their records and details, and consider creating a chronological notebook. Make sure everyone who has information about the dispute is included in the mediation. And be sure everyone knows for what part of the story they are responsible. Brainstorm your positions and interests. What does your client want the other party to do to resolve the dispute? Attorney's fees may be discussed at the mediation. However, it's most helpful when attorney's fees are discussed among the parties prior to the mediation, and it's decided beforehand what part the attorney's fees will play in the mediation.
And finally, here are several resources and references for you to consider on this topic. And mediation requests are made through the Office for Dispute Resolution. Additional information is available through their website here. And we want to thank you very much for your time today.
Thank you.